Declare the House in committee for consideration of the Policing, Storage of Youth Particulars Amendment Bill. Mr. Chairman.
Mr. Speaker. Members, the House and Committee on the Police, Storage and Youth Identifying Particulars Amendment Bill, and the question is that Part 1 stand part. Keith Locke.
Thank you, Mr. Chairman. The Green Party has argued in the first and second readings that the process we're going through is a travesty of the parliamentary process, rushing this through an urgency. And a lot of the argumentation by both National and Labour speakers has been that this is all just about restoring the status quo. And they're using the fact that there was not a lot of debate around this provision when the Policing Act went through in 2008. In fact, there was no debate around this provision, for saying, well, somehow that the intention of the legislation is the way they want it, that particulars could be kept by the police of basically the whole range of people involved in youth offending that come before the youth court. In fact, the fact that there was no substantive debate on the 2008 policing bill doesn't make a case one way or the other. If there was no debate on it, you can't say the intention of Parliament was in any particular direction. Labor can come out and say, well, we were the government then, and our intention was in this direction, and I'm sorry we got it wrong in the legislation. Labor can say that if they like. National can get up and say, well, we now believe that the intention of the bill was this or that. But Parliament is made up of all the MPs and parties in Parliament. And the Green Party didn't engage with this particular clause in the 2008 bill because we weren't aware of all the implications, that it wasn't part of the general debate, so we didn't commit an argument one way or the other on this particular provision. So the idea that we, or the Māori Party, or any other party, had a particular intention in 2008 that can be divined by the Labour or National speakers now is nonsensical. And what has happened as a result of this debate is that there clearly is a substantive issue there. Once this issue has been brought to the attention of the whole House, including the Green and Māori parties, there is a substantive issue. So it isn't just correcting an intention of Parliament. It may be correcting an intention of the Labour government. It may be correcting an intention of the National Party, but it isn't correcting the intention of Parliament. And so rather than say, oh, well, we can rush this through in urgency under our definition of the situation, as Labour and National is doing, they've got to take into account Parliament, and particularly the substantive issue that has been raised. And then the last speaker, or second to last speaker for the National Party in the second reading, says this situation has applied since 1958. Well, just dissect that a little bit. In 1958, there was no youth court. Our methods of dealing with young people, I'm not an expert on what it was in 1958, but I think it was probably a little bit backward, and that's another reason for having a proper consideration of this bill, so that we can actually look at what the treatment of young people back in 1958 was. We do know that it wasn't until 31 years later, in 1989, that the youth court was set up. So for the National Party speaker to say, as she did, that all these provisions have applied since 1958 when there wasn't even a youth court in 1958 is nonsensical, which is another reason why we've got to have a substantive discussion of this provision. And as Rahui Akatani has said, the Māori Party is out consulting their networks now that they are allowed to, because they don't have to hold the conferences post 9:30, I think Rahui said this morning. And there is clearly not only a Green and Māori Party MPs debate in this House, but there is a community debate starting up around the question of, for example, under the provisions in the Children's and Young Persons Act, there's subparts A to N, all the different penalties that can be applied to young people short of conviction, and one of these, as my colleague David Clinton mentioned, is in the first one that comes up. Mr. Chairman.
Keith Locke.
One of these that comes up is, in its subsection A, is admonishment. And the idea that in 2011, someone being admonished for the most trivial of offences in the youth court should then have their fingerprints and all kinds of things preserved is against the modern concept of justice and youth justice in particular. And we have in this Parliament passed bills like the Clean Slate Bill, etc., reflecting a more modern concept of justice, that we don't want to tar offenders with things they may have committed in the past. And surely, an 11-year-old or whatever it is, committing an offence, a minor offence that is dealt with by admonishment in a youth court, is not the sort of offence that should be necessarily followed by all kinds of personal details and fingerprints, etc., because we want to create in that young person the feeling that after their admonishment and the family sort of telling them they've done wrong and all the rest of it, that they put all that behind them. There's nothing in the police records in terms of identifying characteristics and fingerprints and all the rest of it, and they can go on to a whole new life. They might have shoplifted a box of chewing gum or something like that. Then when the Labour speakers, Carol Bowman, I think, talked about, it's good to have a debate on the causes of crime. Well, this provision is actually a good point for a discussion of the causes of crime. And one of the problems of reoffending, and I think it does, and I really respect what Rahui Katani said about Māori offending and targeting and all the rest of it. One of the problems in repeat offending, including Māori offending, is people getting alienated from the system by feeling that they are being unjustly targeted. And to have a softer provision whereby, all the stuff is not kept on someone who is admonished in a youth court for stealing a packet of chewing gum is one way of getting rid of that alienation, reducing repeat offending. That's all modern thinking in relation to responses to crime, particularly youth crime, much more modern than existed in 1958 in the Act that the Police Act that has been referred to in the debate. Now, the question of urgency and why we need it, and my colleague David Clendon said this. Now, is there going to be piles of court cases and huge amounts of money? Annette King said, well, I've come up with this figure of $6 million. In fact, it's in the regulatory impact statement put out by the police that possibly 20% of these cases, that is the previous cases where identifying information was collected on young kids and used in a subsequent case, that 20% of these cases would be appealed and could cost $6.2 million. And just, a bit of common sense that when kids and their families have been through this process, they don't want to resurrect it. In 99-point-something% of cases, they're not going to go through all this appeal stuff and cost the country millions of dollars and all the rest of it. And that, if you don't believe David Clendon and myself on that, then perhaps that's why we should have a whole process around this bill. Select committee, get the lawyers in, get the people, the child, youth and family people in. Say, what is the situation? Would there be a lot of appeals? What are the advantages and disadvantages of not collecting all this identifying information on some people who've been subject to minor penalties, diversion, admonishment and whatnot in the youth court? Why don't we have that discussion? And there is a certain embarrassment amongst the Labour and National speakers about this being retrospective legislation, and there's been a lot of criticism of retrospective legislation by the legal profession. I think that is another very strong reason for not supporting this bill and actually going through a proper process whereby we can have all of the discussion. Like even this whole question of the relationship between the 2008 Act and the 1958 Act. I haven't had time as a Green Party speaker here to look at all the amendments to the 1958 Act. I know that the 1958 didn't deal with the situation where there was a youth court, because that wasn't established until 1989.
Honourable Leanne Dalzell.